more on this story, we're now joined by NUMSA's Phakamile Hlubi Majola. Phakamile, good to have you. Thank you so much for your time. Let's talk about the contents of the papers which you filed against the business rescue practitioners. What do you say in those papers?
Good afternoon, and good afternoon to your viewers. Effectively, what we're saying in our papers, we are asking for an order from the court to interdict the business rescue practitioners from imposing any kind of retrenchments against workers outside of the Labour Relations Act. And this is very important because last week, when the business rescue practitioners announced the cancellation of the 11 routes, in the same week they had also said that they wanted Labour to agree to mass retrenchments outside of a Section 189 consultation process. And of course, as Labour, we reject that. And this court application is simply an attempt to force the business rescue practitioners to act within the confines of the law. The second issue that we've placed as and it's something that we would like the court to grant an order on, is we want the court to order the business rescue practitioners to implement the training layoff scheme, which is a condition of the wage agreement which NUMSA and SAA negotiated last year. This scheme is a cost-saving measure, and what it really is that workers who are facing retrenchment, instead of going on retrenchment, they are placed on training for a period of 6 months to a year. Their salaries are paid for by the SETAs and are not paid for by SAA. And for us, this is something that is really going to give the airline some breathing space and allow it to, recover financially, and also for us to actually devise a business rescue plan, which we can then implement to turn the airline around.
But Phakamile, I understand that this agreement with regards to, the layoff, scheme was already signed into agreement with, the SAA or other business practitioners. Are you saying that they are totally and deliberately disregarding that agreement by going through the retrenchment route?
Well, absolutely. They have said in our consultations with them that they don't have any choice but to embark on these drastic cost-cutting measures. And our argument is simply that you actually haven't exercised all the options that are available to you on the table. We went and agreed with SAA last year that this was something that would be implemented because we knew it would give the airline an immediate saving and give it the kind of breathing space that it required so that business rescue could actually happen. We were shocked to discover last week that the South African Airways executive management unilaterally just withdrew this part of the agreement without even discussing it with us as NUMSA and SAA. So we are now going to court in order to enforce our rights and to protect jobs. But also, more importantly, I think people must fully understand here that the problems at SAA are not because of labor cost or the wage bill. It is because of the continuation of the corrupt procurement contracts, which, as we speak, the Zondo Commission has been unveiling in great detail, that continue to run at South African Airways. And one of the things that the business rescue practitioners are failing to do is to cancel or renegotiate those contracts. In terms of the law, they have the power to do so, and we just don't understand why they haven't exercised that power all this time.
So we had this conversation before, Phakamile, right before Les Mattison was appointed as the business rescue practitioner for SAA. And I remember vividly you saying that one of the conditions you have for SAA as well as its new BRP was constant communication and consultation on any decision, especially that would affect workers. Now, have you been consulted, number one, with regards to the retrenchments of workers, but also to these cancelled routes, which the BRP has announced?
Certainly no consultation whatsoever. What we got was an information sharing session, and even as they were in the process on Thursday of unveiling this plan, they rushed to the media and released a press statement while we were still engaging. So it's really been quite shocking, the kind of engagement that we've had with the BRP. And the law, again, explicitly states that the role of a business rescue practitioner is to engage meaningfully with all stakeholders. As Labour, we have certainly not been engaged with meaningfully. What's happened is that what we are seeing, the business rescue practitioner does not act independently. This plan, this disastrous plan to cancel 11 routes, is a plan which was devised by the very same corrupt executive management of South African Airways. They've devised this plan in order to cover up for their corruption, and the business rescue practitioner is simply implementing it. And this is not the first time he's done this. When the planes were sold, again, the corrupt SAA executive management did so without consulting the BRP. He found out later. And this again even applied to the cancellation of routes that occurred earlier in the year. We have seen consistently that this BR practitioner has not acted independently, and he's certainly not acted in the interest of all stakeholders.
NUMSA's Pakamile Hlubi Majola, thank you so much for your